All right, good afternoon, everybody. My name is Chris Cecil. I'm a shop steward at United Parcel Service in Greensboro. I've been a shop steward for the last 8 years. I was first elected in 2012. I'm also a member of the 391 Forward Rank and File Education Committee. As a committee, we decided that with the recent addition of multiple stewards in our local that have been elected and appointed, especially in UPS, we thought it would be a real positive thing to have a kind of an informal steward training or informal steward seminar. Our local hosts a union seminar for stewards every other year. And the possibility of people attending this year because of COVID-19 is slim. You know, we don't really know what's going to happen with that. And in addition, our stewards, especially our newer stewards, need this information now. They can't really wait. We're going to talk about knowing your rights as a shop steward and as a member. So one of the major things that everyone should be aware of as a steward and as an activist is the concept of just cause. Just cause discipline basically sets the threshold of discipline and basically ultimately losing your job. So there are 7 tests of just cause. And when I say 7 tests, I don't necessarily mean what your manager is going to be looking at. I'm really meaning what an arbitrator is going to look at in case this case goes to panel and a member is arbitrarily dismissed. So the first test of just cause is a reasonable rule or work order. Does that mean that this rule or order is related to the orderly, efficient, and safe operation of the business? Is it straightforward? Is it easy to understand? Is it consistent and unbiased in the application? And what's the department's disciplinary record for violation of this rule or standard? So a reasonable rule would be you have to be at work on time. You have to be at work unless you're excused off with PTO or family leave or something in that nature. That's a reasonable rule. An unreasonable rule, I'll give you an example at UPS. If an employee is ordered to do something unsafe, probably the best example I can give from personal experience would be an employee that was ordered into a truck that had a leaking hazmat. That is not a reasonable work rule at all, or work order. If a member was dismissed from their job for refusing to do something flagrantly unsafe, an example that would also apply to freight and UPS would be operating a vehicle with tires that are in bad shape or improperly functioning lights. It's not reasonable to order someone to operate unsafe equipment. And quite frankly, it's in most contracts and in company policy that you have the right to refuse that. And in an instance where someone operated in good faith and was terminated, an arbitrator would almost certainly reinstate their job if there weren't other factors going in. The second test of just cause is notice. Did the employee receive adequate notice of the work rule or performance standard and the possible consequences of failure to comply? So let's say, for example, there's a production standard. Now at UPS, we don't have a production standard per se in our contract, but if there was a production standard, the employee has to know about it and they have to be informed of the possible consequences for not complying with that. Another one would be a new rule. If a new rule is instituted, I guess a good example would be taking personal calls at work. This would apply more in an office setting. There are unionized office workers. If that policy was changed that you can no longer take reasonable personal calls at work and no one was notified. You have to be notified. There has to be a meeting or a communication. It can't just be arbitrarily changed. There has to be some sort of notice for these changes. An example at United Parcel Service would be the cell phone policy. Our members, even though we filed a grievance, were no longer permitted to bring their cell phones into the facility. It's going to start being a disciplinary issue, a progressive disciplinary issue if they failed to comply. But they ultimately had to be notified of that change. Someone, if they were on vacation when that notification was given out, they couldn't just be disciplined on the spot. You have to be notified of this work rule and the consequences. The third test of just cause is sufficient investigation. Was an investigation conducted before taking disciplinary action? Why did the employer think a work rule was violated? Is the employee able to perform the task? Were there witnesses? Are there written records pertinent to the case to the employee? For example, for that would be an observation. UPS loves doing safety observations. How do you discipline an employee for discrepancy in their methods if they've never had the methods reviewed with them? The fourth, and probably one of the most important, except for the number 6, test of just cause is a fair investigation. Was the investigation fair and objective? How long ago did the infraction occur? Something very important to note, especially for stewards, is many contracts have time limits for discipline to be issued. At UPS, I know that it's 10 working days. That's the time period that the company has to conduct their investigation. That's more than enough. If I've had it happen several times where management fails to investigate, or they don't get around to having the disciplinary meeting, and ultimately they miss their time window. They have 10 days. That's all they have. If they come to me as a steward on the 11th or 12th working day, that discipline is thrown out. It's not valid. And the same thing goes with the grievance procedure. That's something else we'll cover later on. But there are time limits in the contract for discipline and for grievances. If these things are not done in a timely fashion, they'll be ruled invalid. The 5th test of just cause is proof. During the investigation, was there actual misconduct? Evidence has to be substantial. It can't be flimsy or circumstantial. Even at work and even under a union contract, it's not quite the burden of, say, a criminal trial, but most contracts do assume innocent until proven guilty. A prior history of something is not necessarily proof that a member did something, and we have to keep that in mind. This is probably the most important test of just cause, and if you're taking notes, I would underline this and highlight it and probably circle it, because this is absolutely something that as stewards and even as members we should keep in mind with discipline. It's a concept of equal treatment. Have the employees been dealt with equally without discrimination? Are these work rules applied consistently? Is everyone held accountable for the same standards? Have employees in similar situations receive the same kind of discipline? And what's the record for that department or shift dealing with that kind of infraction? Probably the best example of this I can think of, I'm sure this individual doesn't want me to call them out by name, but there is a very good steward that I know of that had an issue with employees being on their cell phones. Management had the issue, and they were disciplining people, which, quite frankly, that's something that is their prerogative. They have the right to want their employees to not be on their phone and to be performing their job while they're being paid if they're not on a break or, before or after shift. And literally another employee, while others were being disciplined for this, would be on their phone, on Facebook, on Instagram, doing whatever in full view of management. And nothing was happening because, this was somebody that, maybe had a long relationship with the supervisor. They had known each other for years. They let it slide. Point blank, the steward dealt with it the best possible way, basically saying, you're going to hold everybody to the same standard, or you're not going to have a standard at all. And that's the best way to handle that kind of situation. If somebody's being written up for being late, then everyone should be held to the same standard and disciplined in the same way. And as stewards, we have a responsibility to make sure that favoritism doesn't win the day in the shop. The person that goes out and gets beers with the supervisor after work, or goes to ball games with them on the weekends or whatever, is not getting some kind of preferential treatment. We're talking about that particularly in a disciplinary setting, but that should really apply in other avenues as well, whether it be early startup time or overtime. That is one of our most important responsibilities in the shop at Stewards is to make sure everyone is treated fairly, and using the contract to really guide our actions on that. And the seventh test of just cause is going to be appropriate discipline. How is it decided that's what's appropriate? Simply put, the punishment must fit the crime. Is the discipline reasonable? Is it related to the employee's record? Is there a pattern? Is the supervisor that's handling the discipline actually authorized? A big one at UPS is a part-time supervisor does not have the right to terminate an employee. And really, even a full-time supervisor doesn't have the right to terminate an employee unless a manager is at least aware of the situation. So point blank, if a part-time supervisor is trying to take the idea of one of our members and fire them, that's a no-go. That is, they are absolutely not authorized, and that would fall under appropriate discipline. Minor infractions do not merit hard discipline unless there's repeat occurrences. You know, I guess a good example of this would again be at United Parcel Service with attendance, with people being late. If an employee is late for the first time, you know, and the company wants to issue a warning letter, that is probably pretty harsh, unless this is, you know, a repeat occurrence and part of establishing a pattern. That would also really apply to employees being dismissed or terminated for attendance. There has to be a pattern established. Also under appropriate discipline, given the same violation for 2 or more employees, are their respective records of service similar in order to avoid a charge of discrimination? Again, you have every right to compare employee records. You know, you have to keep things in mind, such as length of service, overall record, things of that nature. When making the comparison, you know, seniority per an arbitrator would always be a mitigating factor. So if you have 2 employees that have roughly the same length of service that are committing the same infraction, they need to both be disciplined the same way. If you have one employee who's been with the company 10 years and they've gotten a warning letter for missing 7 days, 7 days of work with call-ins, and you have another employee that's been there, let's say 9 years, and they've only written up and they've had 8 call-ins, then that discipline is not appropriate. Now, we're not supposed to solicit discipline for the second employee that has more call-ins, but that discipline has to be equal and appropriate. A couple other things I'm going to cover is something really important especially when you're acting as a steward, and that is the concept of protected concerted activity. Protected concerted activity is a legal term used in labor policy to define employee protection against employer retaliation. It's really under our constitutional right of freedom of association. And the general idea is that it is, actually, I'll just read right from the National Labor Relations Act. This is Section 7. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Generally speaking, protected concerted activity is when 2 or more employees act together. Again, 2 or more employees acting together. This is not some lone wolf situation where someone is going on strike by themselves to get better pay. The whole idea is that it's concerted and that employees are acting together. That is the foundation of trade unionism in the United States. And this applies to stewards and non-stewards. You always have the right to engage in protected concerted activity. There are certain rules to it, but as long as that activity is protected, concerted, it should be protected with, you know, some caveats. A big one is social media. Social media decisions have come down from the labor board in the last few years. Unless an employee is really being ugly about their supervisor directly, using racial slurs or ableist language or, something really ugly, that language is protected. I'll give you an example. If I went on Facebook and posted, "My supervisor treats everyone like shit," that's protected concerted activity. Now, I can't do that on the clock, obviously, but if I did that after work and was blowing off steam, I'd have the right to do that. And if employees commented on it, they have the right to do that. Protected concerted activity is also if you wanted to handbill at the gate. That's a big thing that the Rank and File Education Committee has done, is handbill about union issues and company issues that affect us in the workplace. That is protected under protected concerted activity. There's rules. You can't handbill on the clock. You can't handbill in work areas, but you have the right to do that, especially as a union member. And that activity is protected. The last thing I'll cover is going to be Weingarten rights. And a lot of this material, just no secrets, is being pulled from The Legal Rights of Union Stewards by Robert Schwartz. Robert Schwartz was a labor secretary under President Bill Clinton. It's really an invaluable resource for stewards and members. I highly recommend it, and I'll have a link in the notes that I'll email everybody at the end of the presentation. But this is the actual recitation of your Weingarten rights. Usually this is given out as a wallet card. The Rank and File Education Committee has given these out as wallet cards. And I'll just read that directly. If my responses to your questions could lead to my being disciplined or terminated or adversely affect my personal working conditions, I respectfully request that you summon my union representative. Until my representative arrives, I choose not to answer any questions. That is basically your right to remain silent as a union member in a union shop when you're being questioned by management. I wouldn't advise invoking your Weingarten rights if your supervisor comes up and says, "Hey, how are you doing?" But if you're a package car driver at United Parcel Service and supervisor comes up and asks you about a package that you sheeted yesterday, you have every right to request a shop steward. If management comes up to you and asks you why you were late yesterday, you have the right to have a shop steward. If you reasonably believe that your line of questioning could lead to discipline, you have the right to a union steward. And this is upheld. The Weingarten rights came from a U.S. Supreme Court decision. Now, something critical that we have to educate our members on in the shop is that if a member does not invoke their Weingarten rights, let's say they start getting interviewed by management and they admit to something that they did, or even if they didn't do. I've had people admit to things that they didn't do. And then they want to call for their steward. There is no fruit of the poison fruit from the tree principle as with Miranda rights with the police department. The labor board has ruled against this kind of windfall in the past where maybe a member forgot to ask for a steward and admitted to something. The labor board will not reinstate them. Now, if a steward is requested and denied, that's a different story. But that's where we have to educate our members to refuse to participate in the meeting. If you're in a building where you don't have a bunch of stewards and there's no one's on duty, then that meeting really shouldn't continue until a shop steward is available. You always have the right to union representation. Once again, I'd like to thank everybody for joining this steward activist training hosted by the 391 Ford Rank and File Education Committee. This union is built upon the rank and file and the stewards that serve them. I'd like for everybody to be safe and wish you a good weekend. Take care.